Hi, my name's Ty Hadarali. I'm a plaintiff's lawyer and we concentrate in employment law in New Jersey and New York. I want to speak to you about a case that came down fairly recently on June 14th of this year. It's the case of Megan Maggie et al. Versus Francesca's Holding Corporation. Very interesting case when you're presented with the issue of, do you sign an arbitration agreement? So a lot of employees out there who work for companies are often presented with offer letters or handbooks that may have within it a clause that says if you have any dispute with the company, you agree to waive your right to trial by jury, one of the most sacred rights under the Constitution. You're waiving your right to a trial by jury, and you submit to litigate your claim or arbitrate your claim in binding, mandatory binding arbitration. And the major differential here, of course, is arbitration, no jury. Litigation, you have the jury. And companies, for odd reasons, find it very beneficial to not have the litigation aired out in a court proceeding with a trial by jurors. And so what happened in this case was it was an FLSA misclassification case. So the FLSA is the Fair Labor Standards Act. It's a statute that covers various wage and hour issues, one of which is whether or not an employee should get overtime if they work more than 40 hours in a week. And in this case, the plaintiffs and the class of plaintiffs is about 151 plaintiffs spread out over 3 different states, New Jersey, Delaware, Pennsylvania. And the plaintiffs in this case were basically arguing that despite the fact that Francesca's, which is a clothing store based out of Texas, despite the fact that Francesca's classified us as managers, we really weren't managers. The duties we had were clerical duties, administrative duties, not duties of akin to that of what a manager would have. So the plaintiffs in this case argue that despite the fact that we were classified as exempt employees, we shouldn't have been. And therefore, because of the fact that we worked an average of 55 hours a week, the plaintiffs across all the stores should get overtime. Francesca's moved to compel arbitration, and kind of interesting twist in this case. While the case was pending, Francesca's actually went up to employees, present employees, and said, sign this document that requires you to submit any disputes you have with the company to arbitration. And unfortunately, many employees signed these documents compelling arbitration. Francesca's also said, well, for the people who were former employees, they had signed arbitration agreements. They should be compelled to arbitrate the claims, and also discussed the fact of reaching out to employees who were in other stores and saying they have to also arbitrate claims. This case went to the court, and Judge Kugler decided on June 14th that despite there were a couple of issues. So despite the fact that the store which was a defendant in a litigation, was actually contacting presumptive plaintiffs, the court didn't find an issue with that and said, no, an employer can go up to present employees and discuss with them signing an arbitration agreement. And the court further found that these arbitration agreements were enforceable. So if you're an employee and you're presented with an arbitration agreement, before you sign the document, realize you might be waiving some significant rights, and you may want to consult with an attorney who concentrates in employment law. This is Ty Hadarali. Be safe and be well.